Good evening, everyone, and welcome to this evening's online event entitled Incitement, Insurrection, and Impeachment Inside the Second Trump Impeachment Trial. My name is Gregory Bowman, and I have the honor and the privilege of serving as the Dean of Roger Williams University School of Law in Rhode Island. Thank you for joining us this evening. Tonight's program is an exciting and an important one. The second impeachment trial of former President Donald Trump was an historic event that will affect our country for generations to come. Our program this evening provides an up-close and in-depth view of this moment in history, and we are honored to have as our guests this evening three speakers who played important roles in the impeachment process. Roger Williams University School of Law is Rhode Island's only law school, and we are proud of our strong relationship with our state's congressional delegation. These relationships, built and strengthened over the course of the years, enable us to present this valuable program and learning opportunity this evening to our students and to the wider public. Tonight's event is also special for another reason, which is that it is a virtual online collaboration among three law schools: the Roger Williams University School of Law, Wake Forest University School of Law, and Emory University School of Law. It is our hope and our belief that this sort of collaborative programming offers a new model for law schools and universities going forward. Because we are online, we are able to do something different. We're able to bring together members of Congress and legal scholars from different geographic locations in real time, discuss a critically important current event almost immediately after it happened. That is a new thing, and I hope it is the first in a series of events. We hope you enjoy it. We hope you find tonight's conversation informative. Before I hand the virtual podium over to my colleague, David Logan, who is a professor of law and former dean at Roger Williams University School of Law, I also want to thank our planning committee across the three law schools who are hosting this event this evening. Professor Michael Perry, who is the Robert W. Woodruff Professor of Law at Emory University School of Law. Professor Michael Green, who is the Bess and Walter Williams Professor of Law at Wake Forest University School of Law. Dick Schneider, who is the Associate Dean for International Affairs and Professor of Law at Wake Forest University School of Law. And of course, Professor of Law and former Dean David Logan at Roger Williams. We are deeply grateful to all of them for their planning and their work on this evening's event. So with that, I am pleased to introduce my colleague and my friend, David Logan, who will introduce our speakers and serve as our master of ceremonies for this evening. David, the podium is yours.
Thank you, Greg. And thanks to our distinguished panel that is going to be joining us seriatim over the next hour or so because of congressional schedules that we don't control. So please be patient. We're starting a little bit late because a congressional event came up last night. But we're going to do our best to stay on track to get done in an hour and a half and to give all these three players in this really remarkable legal and historical event a chance to describe what it was, what they saw through their eyes, and was really a real-time event. The format will be, we'll begin with Professor Gerhart, and I'm going to introduce each of the speakers in a little more detail in a minute. It'll be followed by Senator Whitehouse, because he can break away earlier, and then Representative Cicilline will come in towards the end, and then we'll have a period of question and answer at the last 15, 20 minutes or so of the presentations. We do have the capacity to field questions from students from the three law schools. It's a Q&A function. I can make no guarantees that we'll get to any of the questions. We've got 820 people registered, and I've gotten a slew of questions already, but if something moves you, feel free to use the Q&A function, and if we have a chance to slide it in, we will try and do it. Let me introduce the three presenters tonight. First is Michael Gerhart, who is the Burton Craig University Professor of Jurisprudence at the University of North Carolina School of Law. He is also Scholar in Residence at the National Constitutional Center and Visiting Scholar at the University of Pennsylvania Law School. One of our country's preeminent constitutional law scholars, Professor Gerhart began his teaching career at Wake Forest College of Law and later served on the faculty at William and Mary College of Law and at Case Western School of Law, where he also served as dean. He has written numerous influential articles and books, including in 2018, Impeachment, What Everyone Needs to Know, the Oxford University Press. And just this month, his latest book has come out. It's called Lincoln's Mentors, The Education of a Leader. Professor Gerhart, though, is no denizen of the ivory tower. Since 1994, he has regularly advised senators during the confirmation process of multiple nominees for seats on the Supreme Court of the United States. And in recognition of his expertise, he was asked to testify for both Republicans and Democrats during the impeachment trial of William Jefferson Clinton. Mr. Gerhart testified in the first Trump impeachment trial, and he served as special counsel to Senator Leahy, who was the presiding officer during the second Trump impeachment trial. He is an elected member of the American Law Institute and a familiar presence on CNN and NPR. Mr. Gerhart grew up in Mobile, Alabama, and here's a fun fact. He was the #2 ranked junior tennis player in the state when he finished up high school. We will soon be joined by Senator Sheldon Whitehouse, who's had a distinguished career as a public servant. After graduating from Yale College and the University of Virginia School of Law, he clerked for the Honorable Richard Neely on the West Virginia Supreme Court. And then he came home to Rhode Island to begin his legal practice, working first as a staff lawyer in the office of the Rhode Island Attorney General. He then moved to the executive branch in Rhode Island and served Governor Bruce Sunland in a number of capacities, including serving as the Director of Business Regulation. In 1994, Mr. Whitehouse, Senator Whitehouse, joined the federal government when President Clinton named him to be the United States Attorney for the District of Rhode Island, the chief law enforcement officer on the federal side in our state. 4 years later, he returned back to the office where he started when he was elected the 71st Attorney General for the state of Rhode Island. In 2006, he defeated incumbent Lincoln Chafee and became the junior United States Senator from the Ocean State. Senator Whitehouse has been an impact player in a number of ways during his service in the Senate. Perhaps most importantly, he is known for his effort to make climate change a national priority. He has delivered 279 time to wake up speeches on the floor of the Senate, in which he attempts to focus national attention on this incredibly important issue of climate change. And here's a fun fact about Senator Whitehouse. He was the author of Appointments by Legislature under the Rhode Island Separation of Powers Doctrine, The Hazards of the Road Less Taken, which was the very first article that appeared in the very first volume of the Roger Williams University Law Review. David Cicilline is a graduate of Brown University and Georgetown Law School. He returned to Rhode Island after completing law school, and he quickly became one of the go-to lawyers for criminal defense in the state of Rhode Island. He also served 4 terms in the Rhode Island House of Representatives. He was elected to 2 terms as mayor of Providence, our capital city, where he gained national recognition for his work as a founding member in the bipartisan coalition Mayors Against Illegal Guns. Congressman Cicilline was elected to the U.S. House of Representatives in 2010, and like Senator Whitehouse, his time in Congress has focused on environmental and water quality issues that are so important to our state. Representative Cicilline has also been a leader in congressional efforts to use antitrust law to rein in the massive power of social media giants. Last July, he led the charge in his capacity as chairman of the House Subcommittee on Antitrust, Commercial, and Administrative Law when he cross-examined Mark Zuckerberg of Facebook, Tim Cook of Apple, Jeff Bezos of Amazon, and Sundar Pichai of Google regarding the charge that they behaved in anti-competitive ways in the use of their platforms. Representative Cicilline is co-chair of the Congressional LGBT Caucus and has been called a rising star in the Democratic Party. And here's a fun fact. Representative Cicilline used to teach a course on advanced criminal procedure at Roger Williams School of Law. So with that background, I'm going to turn the virtual microphone over to Professor Gerhart. And for about 20 minutes, 25 minutes, he will share with us both the perspective on the impeachment process historically, and also his insights into the two Trump impeachments that we have witnessed in the last 18 months. Professor Gerhart.
Thank you, David. And I want to thank the three law schools sponsoring this program. And it is an enormous honor to be included, especially with the two distinguished public servants who will be joining us as well. So it's my role, I think, in part to set the stage. Impeachment is one of those things that most people didn't study in law school. Most people didn't even think about in law school. And for that matter, most people didn't think about it in terms of legal scholarship as well. And that was because impeachments used to be rare. There actually used to be a time in American history where that statement was true. Most of the people that had faced impeachment were judges. Coming into the 21st century, we had only a couple presidents face impeachment. The first was Andrew Johnson in the middle 18th century. Johnson, of course, succeeded to the presidency after Abraham Lincoln was killed. And Johnson was a uniquely unpopular figure who managed to get everybody angry and who went around cursing Congress and trying to obstruct Reconstruction. He was rewarded with having been impeached in the House. Eventually, the House tried several times, but eventually the House succeeded in impeaching Johnson when he refused to follow the Federal Tenure in Office Act, which would have required congressional consent to his firing his Secretary of War. Johnson thought that law was unconstitutional. He didn't consult it. He violated it. The House impeached him. And then he faced trial in the Senate where he fell one vote short of having been convicted. So Johnson was an unpopular president who wasn't convicted. And then we come to another president in the 20th century, Richard Nixon, who faces impeachment for what is sometimes thought of as a paradigmatic case. He had obstructed justice. He had ordered the IRS and FBI to investigate his enemies, harass his enemies. And so as an investigation got closer to Nixon, he fired the special prosecutor who was trying to not just investigate him, but get possession of taped conversations he had made in the White House. Special prosecutor appealed the decision relating to the taped conversations all the way to the Supreme Court, and we now know that case, United States versus Nixon, unanimously commands Nixon to turn over those taped conversations. And that was pursuant to a subpoena, I might add. And Nixon, at the same time as, or shortly after the Supreme Court had ordered him to turn over the tapes, Nixon was already the subject of impeachment hearings in the House of Representatives. The House proceeded to approve 3 impeachment articles against Nixon, and then shortly thereafter, Nixon resigned. So there was never a completed impeachment, much less a trial in the Senate. Next, impeachment takes a president as its subject when Bill Clinton comes into office, and Bill Clinton ends up being impeached for obstruction of justice and perjury, both relating to information concerning a White House intern with whom he had sexual relations. Clinton denied all that under oath, which in law school you'll learn is called perjury. And so the House impeached him, but it was largely a partisan vote or by a partisan vote. The matter got to the Senate, where all Democrats held together to vote to acquit him, and therefore he fell 2/3 short of the threshold needed for conviction. Now, what we've seen so far is a pattern. So far, we've had 2 presidents face trial. That's Johnson and Clinton, both acquitted. One was very unpopular. The other was rather popular. The next president to face impeachment was Donald Trump. And it happened very fast after a whistleblower called attention to a conversation that President Trump had with the president of Ukraine, in which Trump asked for a favor, the favor being for the president of Ukraine to put forward a false story about initiating an investigation into Joseph Biden, whom Trump suspected would be his opponent in the next presidential election. On that score, Trump was right, but the House responded to this information, particularly the House Intelligence Committee began gathering information, interviewing witnesses, various executive branch personnel who really reinforced what the whistleblower had already said. And so the House Intelligence Committee found the president at fault. It put together a report and referred that to the House Judiciary Committee, which then held hearings, which concluded in the House approving 2 impeachment articles against President Trump, one for abuse of power and one for obstruction of Congress. And the obstruction of Congress related to the fact that President Trump had refused to comply with 10 subpoenas. He had also ordered the entire executive branch to refuse to comply with subpoenas. And this was in contrast to the impeachment article that had been approved against Richard Nixon. The third article had actually alleged that Nixon had failed to comply with a legislative subpoena. That was just one. Trump had failed to comply with 10. It didn't matter when the trial started or ended in the Senate. The Senate, by a party line vote, with only Mitt Romney joining the Democrats, ended up acquitting President Trump. The Senate came nowhere near the 2/3 necessary for conviction and removal. And then we come to this year. So if you're keeping score, we have had an impeachment in 2019, a trial in 2020, but then late in 2020, we ended up with a situation that I think was largely becoming evident to everyone. The presidential election was won by Joseph Biden. Every neutral, impartial decision maker, every court that's looked at it concludes Biden wins. The Electoral College reached the same conclusion, but President Trump reached a contrary conclusion, unsupported by the facts. He kept arguing that he had won the election in a landslide and was looking for various ways to upend the election and get himself declared president yet again. The only problem is the law didn't recognize him as such, and time was growing short. And then coming into this year, President Trump held a rally on January 6th in Washington, the results of which were shown all across the United States and the world. We all witnessed an attack on Congress, the first attack by American citizens on Congress, not just breaking doors and windows and locks and windows, but also threatening the lives of the members of Congress, particularly the Speaker of the House, Nancy Pelosi, and 5 people, I think now 6 people, ended up dead as a result of the attack. President Trump claimed no responsibility whatsoever, but I think everybody else, particularly in the House, thought he was responsible. They could put 2 and 2 together, and they therefore impeached him for incitement to insurrection. The matter came to the Senate, and that's what we'll talk about a little bit later. We all know the ultimate bottom line. He was acquitted, but by a historic vote in favor of conviction. 57 senators voted in favor of conviction, and also 7 Republicans crossed party lines to join the Democrats to convict. So we had the largest vote for conviction of a president. We also had the most bipartisan vote for conviction of a president in an impeachment trial. So that brings us up to speed, I think, right now on what happened, but I'm happy to add some color commentary or add others into the conversation.
Well, sure, Mike. Let's go back, pull the lens back a little bit and talk a little about the term high crimes and misdemeanors.
Sure.
And try to slot in these various charges against presidents, because they don't sound like crimes necessarily in the sense that they could be charged for them. They sound like political misconduct. So could you discuss that historically and also how it's played out in the various impeachments that you've been watching?
So one thing we've discovered in all the impeachments we've gone through, including these presidential impeachments I just described, is everybody seems to have to relearn the same lesson. And that same lesson has to do with what's the scope of impeachable offenses. The Constitution tells us that treason, bribery, and other high crimes or misdemeanors are impeachable offenses. Treason is defined in the Constitution. Bribery is defined both in the common law prior to the Constitution's drafting and ratification, as well as in a statute. And we're left with these other terms, high crimes or misdemeanors. These are technical terms of art. And if we look at their origin, it's really in the British system in which these terms are first used. And they are understood in the British system and in the colonies as political crimes. And political crimes were not necessarily felonies, but they were the kinds of abuses that people in power could commit and injure their country or republic. And so what we learned early on about impeachable offenses is they don't have to be felonies. They don't have to be actual crimes. They may be abuses of power for which the law has no remedy, but instead the Constitution has a remedy. Keep in mind as well that the framers broke away from England, in which the king was the only person in the country not subject to impeachment. Everyone else, including private citizens, were subject to impeachment. And the king was basically a law unto himself. The framers broke away, issued the Declaration of Independence, which is simply a collection of articles of impeachment against the king. And these articles of impeachment were designed to show that even a king, even a president, should be subject to the Constitution and to redress if he abuses his power. So the framers came into the convention with a collective understanding whoever would be the highest ranking official would be subject to impeachment. They concluded it would be the president. And now we have to figure out, of course, again, the grounds for impeachment. With Nixon, obstruction of justice was thought to be a pertinent charge because he had used the powers of his office to interfere with investigations of his misconduct. Ordering the heads of the IRS and CIA to go after his political enemies, classic abuses of power that only a president could commit. By the way, those abuses are not illegal in a technical sense. They're not felonies. They are, I think, abuses of presidential power, meaning they're unconstitutional, and therefore they may become a basis for impeachment, and they were in Richard Nixon's case. In Bill Clinton's case, obstruction of justice was analyzed the exact same way as it was with Lincoln, sorry, Freudian slip of weird sorts. It was with Richard Nixon. And but with Clinton, the argument was also made that he was attacking the courts. That obstruction of justice is essentially a president's attacking the courts, and that seems to be quite incompatible with the office. And perjury, lying under oath, is another attack as well on the courts. So the thinking for Clinton was that he was abusing his office, using his office really to thwart being held responsible for his lies and other misconduct. With President Trump, there's really no doubt that whatever misconduct he might have committed was through his office as president. And it's not every citizen who gets to talk to the president of Ukraine, much less asking them for a favor. But the president of the United States can do that. And President Trump did it. There's really no question about it. The real question in the House was, okay, does that rise to the level of an impeachable offense? 3 witnesses, including me, thought it was a serious misconduct that a president committed, one of the highest kinds of misconduct, orders of misconduct, because it really compromises the office of the presidency, and then it is done in order to thwart or undermine a presidential election. That's really what was in play in the first impeachment. Some members of the House doubted it was an impeachable offense. Many senators doubted it was an impeachable offense. But in trial 2, I think there was almost universal recognition that incitement to insurrection is an impeachable offense. It's hard to imagine what else is an impeachable offense if a president's using his office to attack Congress, to physically attack and threaten Congress. That's about as bad as it gets. And that easily qualifies, I think, as an impeachable offense. I think in the Senate too, widespread recognition that would be an impeachable offense, but then in the Senate, there was a jurisdictional question, whether or not the Senate still had jurisdiction over somebody who had left his office and therefore could subject that person to a trial. And so the questions in each of the different proceedings against President Trump were slightly different, and both together really provide us a rather good foundation for understanding how impeachment works, both how it's supposed to work and maybe to some extent how it's not supposed to work.
Before we go into a few little sort of technical inside baseball questions, I want to just spend a minute with you on this last notion. We've gotten several questions, including one from Colton Erickson, one of our students, referencing an op-ed by Michael McConnell, no relation to Mitch McConnell, right, which said that the House made a strategic mistake, that they brought a technical charge of incitement with all the First Amendment baggage that comes with that, rather than a more global abuse of office or interference with election allegation. Could you speak to that as to whether you think those were viable options? You weren't in the drafting process. I'm not going to ask you to defend that if you don't want to. But just strategically, are they conceptually different charges? And do you think there's something Monday morning quarterbacking, if you think there would have been a potentially different outcome if the charge had been less technically incitement and more an abuse of government.
Well, I don't know if there would have been a different outcome. I think that people had thought the numbers were always going to work in favor of ultimate acquittal, though there were more votes to convict than expected. Maybe a slightly different worded article might have made a difference. What Michael McConnell suggested, I think, is very thoughtful. He suggested, yes, a broader article, rather than one that tracked a felony, would have been more fitting for this situation. And I actually agree with him 100%. And that's a rare thing, actually. I would agree with him 100%, but I do in this instance. And I agree for the following reason. One of the debates that always arises with impeachment, and it arose in Trump impeachment proceeding number 1, again, had to do with what's an impeachable offense. And the defense in impeachment proceedings almost always makes the argument that impeachable offenses have to be actual crimes, the kinds of things you read in federal statutes, or maybe even in state criminal statutes, if it's something as heinous as murder. But it's got to be an actual crime. That is a good defense because it narrows the field for possible impeachable offenses. But it neglects to really grapple with the fact that impeachable offenses don't have to be actual crimes. Nevertheless, because the word crimes is in the Constitution, and some people are lazy and they just assume therefore crimes have to be somehow alleged. And so defenders will make the argument that it has to be a crime. And that sometimes becomes a problem for the prosecutors or House managers who are putting forward the case for impeachment. House managers do it particularly in the Senate. And I think it's possible in this current situation that too much effort was spent trying to track an actual felony or crime in the House. And that became a two-edged sword. On the one hand, it could be argued, yes, it looks like a felony, and therefore we kind of get around whether or not it's really a crime or not. Of course it's a crime. But then it runs into a problem. And the problem is, does it really track all the elements of a crime? And then what we found in the trial was that the House managers got drawn into arguments about the elements of the crime. And that's where we get much of the American people gets lost in the weeds and not sure whether or not, okay, has a crime been shown or not, when in fact a crime doesn't have to be shown. So Michael McConnell, I think, quite astutely cut through all that and said, look, if it were broader, let's say betrayal of the country, that's an awful thing. That's a really awful thing. And it's an impeachable offense. It may not be, there may not be a crime that tracks that, but it's not what a president should be doing, betraying his country. And that might have drawn more support, if not in the House, maybe in the Senate. I don't know that that 2/3 threshold can ever be met, even in this last situation. But I think McConnell is probably right that it would have been more understandable for the American people and would have fit better within the impeachment process we've inherited from the framers.
Like to check and see if Senator Whitehouse is online yet.
He is.
Senator Whitehouse, welcome. Thank you. Thank you for
David.
finding time in your absolutely crazy schedule. I've already given you a glowing introduction, so it's your chance just to dive in. Professor Gerhart's given us basically the history of impeachment, presidential impeachments, and we spent a little bit of time just now on the question of whether strategically it was wise to focus on incitement rather than some other broader abuse of power kind of charge. So now a chance, we're now on the floor of the Senate, and we have Senator Sheldon Whitehouse, who's both a fact witness, I'm guessing, and also sitting in judgment. And we'd love to hear from you about your insights, both at the lofty philosophical level, but also the practical challenge that you faced, I guess, for the second time recently, being a juror in an impeachment trial. Not what you thought you'd signed up for, I'm guessing.
Trump does seem to keep getting himself impeached. The first reaction that I have is that it's intimidating to follow Professor Gerhart, but I'm delighted to try to fill in. No, the first thing is how well done the prosecution case was by the House managers. I was really proud that my colleague in the House, David Cicilline, was one of them. And he's a very experienced lawyer and advocate. So it came as no surprise that he did a terrific job. But they really did a wonderful job across the board. I think Joe Negus's career was launched by the quality of his performance. Nobody knew who he was beforehand. I had traveled with him, so I knew who he was, but he certainly wasn't a Washington figure. And I thought Jamie Raskin was pretty stunning. And when you know the personal backstory, it was even more stunning how he was able to rise to the occasion. And with no offense to the professors among you, I really can't help but think of Professor Raskin toiling in academic obscurity and studying the First Amendment and the case law and putting all that work in. And then came his moment in front of the country to call on all that work, all that research, all that expertise that he had marshaled for this moment, not knowing it, I guess, all those years. And there was something really touching about his performance and the way he presented the case. His ability to rattle off, the entire preamble from memory, for instance, was pretty impressive. And, somebody mentioned a case, he knew the case better than the person who'd brought it up. So you had this really good, carefully done, I thought, superb presentation. And then you had the frustrations. And one frustration was that this was a tampered jury. And for all the reasons you don't want juries to be tampered with, it's frustrating when you're in a tampered jury, because there was really almost no way that you were going to get enough Republican senators to vote to convict. I mean, Trump would have had to come in to confess and ask to be convicted, I think, for that to happen. So it must have been frustrating for the managers as well. But I view the managers as having had 4 audiences. One is the Senate, of course, but the others are the general public, and people were tuning in huge numbers to see this, and history, and the judgment of history matters. And then finally, their own consciences and the need to act when you're presented with a wrongful circumstance like this. And I just very firmly believe that they won their case with the public and with history, and of course with their consciences. And indeed, at 57-43, they actually kind of won the case. They just didn't get the removal and the proper judgment. But 57-43 in almost any other forum is a win. The other thing that was frustrating was having to hear the defense counsel argue to us because they were annoying people who were arguing false propositions draped in gratuitous insults. And unlike appellate judges or judges listening to an argument in the courtroom, we had no right to interrupt or question. We just had to sit there. And so they could be really pretty rampant, knowing that the jury was tampered and we couldn't ask any real questions. These little ceremonial, I pass a question up to the chair things, are anybody who has to ask hard questions know that that's not going to work. So there was no real questioning the way a hot bench, appellate bench would challenge a lawyer. So they ran pretty wild. And that was more or less my experience. I'm happy to take questions and have this be a conversation.
Well, I see Congressman Cicilline has joined us, and
why don't we let him chime in and we can do our questions together?
Yeah. Congressman Cicilline, welcome. Thank you for finding the time in your absolutely crazy schedule, and it's great to see you.
Great.
I told him that you really suck, David. Everybody else did a good job except you.
I heard you say those nice things, Sheldon.
Well, it's a lot of this is just a Rhode Island story, right? But the links between the law school and the congressional delegation are just very tight. And we're honored to have both Senator Whitehouse and you here this evening. Professor Gerhart, as you know, sort of gave us the 360 on this. I have a bunch of technical questions about the presentation of evidence and secret ballot and things like that I might want to bring up later. But would you start by just sort of telling us the journey you were on when you were honored by being named one of the presenters of the case, and what it was like, and what decisions you made, and we'll talk a little bit maybe in retrospect, maybe some other strategic decisions that might have been considered. So please, the floor is yours. Thank you, Congressman.
Thank you. So actually, just a little bit of background, that I began to draft the article of impeachment on the night of January 6th while the assault was still ongoing. I was actually in my office with Congressman Ted Lieu, who had come there to shelter because his office had been evacuated. And we began work on the article actually that evening. But once the House impeached the former president, who was president at the time of the conduct, obviously at the time of the impeachment, the Senate wasn't in session. And in order to transmit the article of impeachment, the Senate has to be in session to receive it. Senator McConnell would not bring the Senate back into session. So to hear him say on the Senate floor, oh, if only you had tried him while he was still in office, like, but for the fact that you refused to bring the Senate back into session, we could have done that, was a little too much to take. But in any event, we really learned some lessons from the first impeachment, which sounds odd, but you have had two impeachments now of the same president. And what we heard and what we knew from our understanding of United States senators is they don't like to be lectured to. They don't like to be told that they're immoral or unpatriotic if they don't do a certain thing. And so we decided in this trial to really prosecute the case with a relentless focus on the facts and to avoid kind of soaring rhetoric or any kind of judgment language, but to literally walk through the events that led up to January 6th and the events that followed it in really kind of incredible detail, literally minute by minute, and to really walk the Senate through the overwhelming evidence of the former president's guilt by way of videos and his own admissions and statements through Twitter and other sources, but really to stick really disciplined in presenting the facts and avoiding all the other kind of language that we think really worked against us in the first impeachment trial. And we also didn't want to repeat, we heard a lot of criticism in the first trial, there was a lot of repetition. And so we were really disciplined about walking through this evidence really carefully in a very disciplined way, but prosecuting it on the facts. And I think, we proved the case, as Sheldon just mentioned, a substantial majority of the United States Senate found the former president of the United States guilty of inciting a violent insurrection against the government of the United States. I mean, think about that. 57 to 43. We didn't reach the 2/3 that was required, but I think we told the story of what happened that day and leading up to that day. And I think the American people understand it. And even the Republican senators who voted to acquit, no one said, oh, I don't think you proved the case, or we think President Trump is innocent. They all relied on these bogus constitutional claims of, you pick it, First Amendment, due process, you can't impeach a former official, all completely unsupported by precedent and the law. In fact, we have a number of cases of former officials that have been impeached and convicted or impeached and tried. In fact, the very first impeachment in the United States was of a former United States senator. So this has always been the tradition in the United States Senate. It's always been the rule. This idea of having an exemption for former officials was newly created by the Senate. And someone asked in the chat box, once that issue was decided on the motion to dismiss, weren't the senators then bound to honor their oath of doing impartial justice and actually decide the case on the evidence? The answer is we thought so. That's what we argued explicitly. But interestingly, in the Belknap case, which was one of the cases we cited, the very same thing happened. Belknap moved to dismiss the case because he was the former Secretary of War. He won the motion to dismiss decisively. They proceeded to trial. He was acquitted. And after he was acquitted, most of the senators in the Belknap case who voted to acquit him said the reason they did was because he was a former official and they didn't think he should be tried. So we were sort of stuck with that. And I think we saw evidence of the same conduct here. But as Senator Whitehouse said, it was important to tell the story to the American people so that they understood what this former president's culpability was. And hopefully, history has recorded it, and the people who voted to acquit him will have to live with the consequences of that for the rest of their lives.
Professor Gerhart, you want to chime in now? Now we've heard from two of the other key players. You were sitting against the back wall, if I recollect correctly, and had Senator Leahy's ear. What do you have to say about some of the comments from Senator Whitehouse and Congressman Cicilline?
Well, now that you've put it that way, David, I've got to say that, of course, I'm here in my own capacity. I'm not speaking for Senator Leahy in any way, shape, or form, and it was a great honor to be able to work with him during this trial. One thing that may just be interesting to add to the mix is the role of the presiding officer. It has traditionally, of course, not just traditionally, it's been constitutionally required for the Chief Justice to preside at a presidential impeachment trial. But I think one of the, I guess, peculiarities might be the right word to use in describing this trial is the argument that some people made, like Senator Paul, well, we need to have the Chief Justice preside. And this is one of those times I can tell my constitutional law class and everybody else, hey, the Constitution answers this question. Should the Chief Justice of the United States be presiding over a trial of somebody who's not president? According to our Constitution, only one person is president at a time, and it happens to be Joe Biden at the moment and during that trial. And so the Chief Justice would not and did not, and he turned down any invitation to do that. Thus, the matter went to the Vice President, who chose not to do it either, and then it falls to the Senate Pro Tem, who in this case happened to be Patrick Leahy. And so the presiding officer is at least charged by virtue of that position to try to be the neutral, even-handed arbiter of the proceedings, trying to keep the lawyers in place, and that was a challenge to be sure, but also being there to make a ruling on a motion if it's made to the chair, or a motion on any other part of the procedure. And I think it was a particular challenge for Senator Leahy because, after all, he's a senator. He got to vote on the trial, and he's also trying to preside. And it will not surprise anybody for me to say I thought he tried to he managed that balance very well. Not an easy one. But I defer to our distinguished guests on sort of the what's actually happening in the trial and what's actually happening in the House side, as well as the House manager's arguments. As somebody who was there and listening, both, I guess, as a counsel and also, I can't stop that law professor part of my head. I thought the arguments were extremely good that the House managers were making. Yes, it was evident they were really stressing the facts, and that's what a good lawyer does if the facts happens to be on their side. And the facts here were undeniable. I think one can infer quite easily the president's complicity in whatever happened on that day. That's just a reasonable inference from the entire situation. The other thing which has just been referred to, though, is how the defense lawyers behaved. They could have just said little. I mean, they had a good idea they'd probably win this case if they said nothing. But I think to please their client, they went way overboard. And all I would say on that front is I would agree 100% these lawyers were, particularly Mr. Vandevern, were quite out of order and actually in violation of a couple of different rules of professional conduct. Rule 3.3, for example, requires lawyers to be truthful and candid before a tribunal. And many of the things that the lawyers said on the defense side were not truthful or candid. They were misleading and false. And the trial may not have been the place to hold them accountable, but there's a record now of their performance, and they're going to be held accountable not just before bar associations, but before history. And as everybody knows, history is very cold-blooded in rendering its judgments.
So, Congressman Cicilline, I guess Senator Whitehouse, we spoke a little while ago about sort of Monday morning quarterbacking and the decision to make it a tight incitement felony case. A number of people have sent in questions asking, why not just go for censure? Or why not just trust the civil and the criminal justice system? As you know, yesterday the Supreme Court of the United States ordered the Trump family to turn over tax records, the various entities in Georgia and New York at the state level are doing investigations and federal investigations. Hindsight's 2020. Would you want a censure vote with the same constituency?
Absolutely not. No, I mean, look, from my perspective, and I think from the entire House Democratic Caucus perspective, the conduct of the president rose very obviously to us to a high crime and misdemeanor. It's the worst constitutional crime of an American president in our history, inciting violence against the Capitol at a time that the peaceful transfer of power is set to occur. It's the very foundation of our democracy, is the peaceful transfer of power. So this was not just an attack on a building, it was an attack on our democracy. It resulted in the death of 5 people, including Capitol police officers, significant injuries to dozens of people who were hospitalized, and obviously tremendous damage to the Capitol, tremendous damage to our standing in the world. The notion of censuring the former president, I mean, we censure people for misusing stationery for personal purposes. Like, censure is not appropriate in this kind of circumstance. So I don't think there's any regret or any suggestion. And with respect to Professor Gerhart's observation about the lawyers, I think he's absolutely right. They were performing for a single client. They were exactly what you would expect of Trump lawyers. They were rude and obnoxious and lied and said horrible things about people and misrepresented, but they were sent there to do that. They were performing. I'm sure they pleased Donald Trump beyond measure, and that was their objective. They knew they sort of had the verdict in the bag. So this was really about keeping their client happy. And by the way, we were like, just the opposite. You remember Jamie was even saying, my distinguished counsel, he was like bending over backwards. There wasn't very much distinguished about them, but we were trying to behave so well and so kind of appropriately on the Senate floor and do deference to our esteemed senators. And they were like, rah.
Senator Whitehouse, do you concur in that evaluation that was not a road to go down?
Short of between censure and impeachment is a legislative finding that Trump violated the 14th Amendment, Section 3 in his actions. And that would bar him from future office, and it does not require an impeachment. It's just a regular vote. So we still have that available to us if we want to go there. It's never been used, and ultimately it probably takes a court to enforce it. The likely way that would come up is that Trump would file papers as a candidate in some state, and then someone was standing would say, you can't do that. 14th Amendment, Section 3 disqualifies you as a candidate. Now, if we went ahead and passed a resolution finding that he had done that, a court could then possibly say, this is the kind of fact finding that is uniquely appropriate for Congress in a situation like this. And therefore, I'm going to either give Congress's finding of legislative fact here great weight, or I'm going to view it as dispositive. But even if we don't do that, the next time Trump files, I'm prepared to bet you that somebody's going to bring an action in federal district court saying, dude, you are disqualified, and revert to a lot of the evidence that David and his colleagues put forward and have it out in a civil case in front of a real judge or a real jury, not a tampered political jury. And so this isn't necessarily over, even if it's over in Congress, and it's not necessarily even over in Congress. The only other thing I'd say is that nobody's a stronger advocate for, everybody being equal before the law and the law, going fearlessly and without favor. But there is one asterisk on that, and that is when a new administration decides to prosecute criminally with the Department of Justice the previous president, because that raises all sorts of potential political overtones. It's not that you can't do it, it's you just got to be like bomb-proof, dead to rights, nobody could possibly disagree. And then, you may want to work out a plea and a pardon or something like that. But it's just weird because you don't want to get into you want to steer far away from any practice in which an incoming administration turns the guns of the Department of Justice on the outgoing president. So that's the one caution about relying on criminal process. I don't feel the same way about New York or Georgia. If the Georgia DA can get him on attempting to tamper with the Georgia election, God bless, that's fine. I don't have an issue with that. If the New York DA can get him on tax or other financial crimes, that's fine, go for it. He's a person like any other. But when it's the new president and the Federal Department of Justice and the previous president, I think we got to be cautious.
I'd like to spend a minute or two, if I could. There have been a number of quick questions, sort of technical questions, lawyering kinds of questions, and let me just roll them out to the three lawyers here. One question was, why not a secret ballot? And would a secret ballot perhaps have led to a different outcome? A second question is
unanimous consent in the Senate, and you're not going to get unanimous consent. And second, in a matter that is this important in this public, I think when you start adding secrecy into the equations, it brings with it suspicion. And that, I think, lets when you consider the atmosphere of falsehood and conspiracy theory that already permeates our politics, even people who, would think that this might make the difference with convicting him, I think there would have been a lot of opposition to that. So it's not just a question of like Rand Paul objecting to something everybody else wanted. This would have been, I think, a very contentious notion.
Nor would the media have accepted that. They would have gone up to every single senator and made them tell them how they voted. It would be inevitable.
Yeah, and some would have been eager to tell them. So then that leaves
Right.
people in a box. So yeah, it's messy.
so a related question. Maybe this goes to Professor Gerhart with the chair, but one of the questioners said, I didn't see the federal rules of evidence being applied. In fact, I see them being abused all the time. Is that constitutionally required? I assume I know the answer to that, not being a constitutional expert. But two, would you comment on your sense about the evidence that was put on both sides, including the argument by President Trump's lawyers that the Democrats doctored the video evidence and the like?
Well, sure. So the federal rules of evidence do not apply in impeachment proceedings. One of the things that happens, understandably, when people sort of grapple with the impeachment process in a really high-profile case, for example, one involving the president, is they tend not to pay attention to some of the other proceedings that occurred before. But in the late 1980s, there were 3 judicial impeachments, and they grappled with this question about rules of evidence, and the Senate rejected, I think quite rightly, applying the rules of evidence in an impeachment proceeding. First of all, it's not a legal proceeding. It's a unique constitutional proceeding. It's not a civil proceeding. It's not a criminal proceeding. Secondly, the framers picked a special decision maker, United States senators, not ordinary citizens that you might have in a jury, or not even judges. And because they picked senators, the expectation was that this group would be more sophisticated, have more learning, have the ability to kind of rise above the politics of the moment to make judgments with the long-term ramifications in mind in this case. And so senators don't need the rules of evidence. They're sophisticated people. They can figure out whether or not they want to lend credibility or find credibility in a piece of evidence, or hearsay or double hearsay, or not. They can decipher these things. Beyond that, I think it's important to also remember that it's not just the rules of evidence not applying. The other thing that's really a part of the tradition here is the understanding, I think, within the Senate But if you had a uniform rule, like a rule of evidence or burden of proof, it'd be impossible to actually enforce that uniformly. Every senator decides for himself or herself what's the burden of proof. And I think every senator decides for himself or herself, okay, is this relevant evidence or not? Now, I think the evidence put forward by the defense was largely not evidence. It was political hyperbole. It was talk radio. It was not relevant in any technical sense at all, unless you buy into the worst kinds of conspiracy theories. And yes, they may have raised a flaw here and there of the House manager's case, but that's not the same thing as defending the president on the merits. What's particularly telling is the president wasn't defended on the merits. And in fact, what exists in this record is, I think, a damning of this president for all time. It's not insignificant that you have not just 57 senators condemning him, but you have a lot more than that, more than 67 condemning the president for his misconduct. You know, I was sitting not far behind Senator McConnell when he gave his speech at the end. Sure, he voted to acquit, but that speech was not an acquittal. That speech didn't let him off the hook. And so you had more than enough senators condemning the misconduct here to ensure that that conduct is condemned for all time.
So let's turn to a question that there was a lot of conversation about, which was the decision in the end not to call any witnesses. And I saw your name, Senator Whitehouse, quoted in, I guess, Washington Post or whatever, having some opinion on that. And would either one of you, without feel comfortable discussing the decision to, I guess, was read into the record the letter from Congressman Cicilline's colleague and not have any live witnesses? That's obviously the option. This is not a legitimate judicial hearing enough to put on fact witnesses either, but would you be willing to discuss that, either of you?
Sure. So oh, sorry.
Go ahead, David.
I was just going to say, you know, we presented dozens of witnesses during the course of the trial by way of video testimony, by way of statements, by way of a reporting of statements of witnesses. So all of that was in the record, dozens and dozens of witnesses. The Senate rules permitted us at the conclusion of our presentation and the former president's lawyer's presentations to make a decision as to whether or not we wanted to call additional live witnesses. So after we presented our case, we waited to see the president's presentation. At the conclusion of their case, he hadn't refuted any of the facts we put forth. And so we had no intention of seeking additional witnesses. Because remember, when you're requesting additional witness, you have to actually have the witness or have a witness who's willing to come forward without litigation, a protracted proceeding, and that they're going to say something useful to your case. So that, you know, at the conclusion of the president's case, we were prepared to move forward without additional witnesses. Then the evening before that, you remember, Jamie Herrera Butler released her statement saying that she had had a conversation with Kevin McCarthy in which he disclosed a conversation with the president of the United States, who he had called in the middle of this bloody attack, begging for help. And the president first said, well, this is Antifa, Kevin. And Kevin said, no, this is not Antifa, Mr. President. These are your supporters and we need help. And he said, well, Kevin, I guess they're more upset about the election results than you are. This was damning evidence that showed the president's state of mind, his failure to honor his oath by intervening at that point to protect the Congress and the Capitol. And so it was really important for us to get this before the American people. Now, I will tell you, at that moment, after Jamie Herrera Butler issued her statement, she went dark. We actually couldn't reach her. Now, I don't know whether that's was she got nervous, she was threatened, she got a lawyer, she did, but we lost contact with her or weren't able to contact her. So now we have the real prospect of one, to get this before the jury, but aren't sure we actually have the witness. The Republicans then are arguing, look, if you're going to call one witness, we're going to ask the Senate to allow us to call one witness, which seems sort of fair. And they think, oh, we think they may call Kevin McCarthy. We have no confidence that Kevin McCarthy will testify truthfully. So he could easily be deposed and say, you know, I don't remember that conversation at all. But one thing I know about President Trump is if he knew the Capitol was in danger, he would have responded immediately. And blah. I mean, we just have no way of knowing what he would say. And so that's some risk. And so when the Republicans agreed that we could admit as full evidence her statement, which is what she would say in a deposition, we got the benefit of her testimony with no risk. And so we saw this as, mission accomplished. And while I think viewers thought, oh, we were going to have a witness come to the Senate floor in this high drama. The witnesses don't come to the Senate floor. You depose them and then you read their testimony in the same way we read her statement. So we felt like strategically, we got what we needed in terms of bringing that before the Senate and arguing it without the risk of actually never being able to track her down or having some other witness contradict her. So that was sort of a trial decision.
And the 2 points I'd throw in, one, a lot of this, the attention to this related back to a tweet that I sent out that got, I don't know, millions and millions of retweets, and that was one of a series of tweets in which I was calling out the misconduct of Trump's lawyers along the lines of what Professor Gerhart said about their misconduct, because it was offensive and somebody needed to be calling them out. And in the course of this, one of the things that they said was, there's no way that President Trump, if he'd known that anybody was in danger, wouldn't have responded. He cares about Mike Pence and he would never do that. So then comes Representative Herrera Butler's testimony. Now the two are in conflict with each other, and it looks like the lawyers have made a false statement to the tribunal. And the way for them to clean up that mess of their false statement against her statement is to let the defense bring them in, which I'm sure David and his team would have readily agreed to, and sort that out and then, go back to trial. The danger of opening it up to witnesses is that, and this is something we'll learn if we ever have to do this again, this is my message to Senator Whitehouse in the future. We got to do a better job of setting up the rules for witnesses, because it turns out that once you open the door to witnesses, then both sides have the right under the rules to demand votes on every single witness that they want to call, which would have let Trump's lawyers submit a phony baloney list of 90 witnesses and make us vote with 2 hours of debate on every single one of them. And Trump would have been chortling down at Mar-a-Lago with the way he discombobulated the proceedings, and they'd pick names not because they had relevant testimony, but to embarrass them, like Kamala Harris, please. So it was going to open up a really unfortunate procedural problem, and we want to get to the COVID bill. I mean, this was important to do, but it was also important to end it and to get onto the COVID bill. So, and there was no real gain from it, as David pointed out. So everything was downside. I won't second guess the call not to proceed. I think they got the information that they needed into the record, and we moved on to the predetermined vote by the tampered jury.
Yeah, and the only other thing I would add to that, Dean Logan, is we also wanted, short of a conviction, we thought it was really, really important that this be a bipartisan vote. And we thought there was also some risk that if we engage in the kind of protracted proceeding that Sheldon just described for 18 hours, or for witnesses that were never going to be called, that we ran the very real risk of losing some of our Republican votes. And what we wanted to avoid at all costs was a vote of 50-50, where it would look completely partisan. It would really have undermined all of the work we did and the kind of strength of our case. So we also had to kind of factor our sense about what that kind of a proceeding would have done to our Republican jurors, who clearly our impression was would not have viewed that favorably, and we would have run the risk of losing. And I think everyone said we got our zenith. We got the top number of Republicans we were going to get, 7, and we didn't want to lose that.
What I find really interesting about this last little conversation is that I see you gentlemen both wearing your lawyers' hats and your politicians' hats, your civic leaders' hats. And that's one of the interesting things, right, about this procedure. So you're thinking all the time about not just what's going to happen with the number of votes you get, but what might happen to your ability to move forward with some of these people in the future, which you have to work with. And I was going to ask, I understand the atmosphere on the floor during the video presentation by the House presenters was quite intense. And I was wondering if the three of you would describe what it felt like to be there on the floor, just as people, not just as senators and voters and prosecutors, but what was it like to be there surrounded by people who were, in many respects, fact witnesses to many of the events that you were discussing? It just had to be a really unique moment for all of you, Mike, Professor Gerhart as well. I'd like to hear each of you spend a minute or two just sort of, what did it feel like to you?
Name somebody.
Politicians aren't good with emotions. I will say this, when we presented this case and when we prepared for it, I don't think there was a single House manager that didn't at some point in our preparation break down. I know the night that Jamie, Joe Neguse, and I saw that introductory video for the first time, that 12 or 13-minute video, I mean, it was hard to watch. And you just couldn't help but be overcome by the terror and the violence and the fear in the eyes of people who were victims to this violence. And even when it was presented on the floor and it was the 10th time I'd seen it or whatever, it just reminded you of the horror of that day. And, for me, at least, it was a reminder of the importance of what we were doing, whatever the result was to be, that it just could not be that a president who would incite that kind of violence against our own government and that harms so many people could just get away with it without having to face some accountability.
Senator Whitehouse, you were there.
Yeah, I think some of the members, both of the House and of the Senate, had particularly disturbing experiences that day. I'll mention on the Senate side, Patty Murray, because she did an interview about it just at that time. And she was in kind of a nightmare situation with the mob chanting about killing people right outside her doorway. And she and her husband couldn't remember if they'd locked the door. And it's like that moment in the nightmare, do I lock the door? But then maybe they hear the lock click. And then they'll break the door down because they're breaking doors down. Or do we just wait here and not lock? It's an absolutely horrifying scenario. And, she's a very physically small person who would have been easy to, harm physically. So I think, there were members in the House and the Senate who were really scarred and really hurt a lot of it back. And for those of us for whom it was not necessarily, so we were nevertheless very sensitive to those colleagues of ours who had a really horrific time. And there was a sense of, oh my gosh, how is, so-and-so doing? How's so-and-so doing? And a little bit of looking around to see how people were holding up. And the other thing was the awareness, which I certainly had not focused on, of how long this ordeal was for the Capitol Police officers. That, as one said, this was a pitched medieval battle that lasted for hours with pikes and staves and direct physical contact, as well as the, gas and the insults and all the rest of it. And, we knew there had been contact and we knew there had been combat, but the duration of it was pretty stunning, and the endurance of these people to stay with it and restore order at the end of that long night was really, it was pretty stunning. I can't walk by a Capitol Police officer right now without feeling a little lump in my throat.
Do you think there's going to be a congressional version of civil defense practices going forward? Or are you now comfortable with the security that's going to be surrounding where you work every day going forward? I mean, the pictures are just sad to see razor wire and National Guard armed. It's not the democracy, of course, that we love, but it may be the politics that we have. I was wondering if either one of you would speak to that.
No, that's got to come down, and it's going to come down, but it's going to stay up until we have a plan for what the better, safer strategy is, what needs to be built. But I grew up in the Foreign Service, and I spent a lot of time in countries where you had to put walls and razor wire around institutions of government, and I never thought that America would be one of those. And as soon as that stuff can't come down soon enough for me.
I agree.
David, can I throw something in?
Sure.
Please.
No, just to add to what has just been said. I think there's a great temptation for people to think that whatever they see on television is just entertainment. In other words, they see things on television, they don't really realize it's real. And so I think that might have happened with the attack on Congress for many people. Oh, we saw it on television, but here's the thing. For members of Congress, it was deathly real. It was absolutely real. People hiding under desks, people.
Gas mask.
Well, yeah, I was struck. I happened to be in the room and saw the video and showing Senator Schumer going one way and then having to run another way. And because that's how close he was probably to getting really badly hurt, if not killed. And so one of the things that was happening in this very proceeding, both on the House side and on the Senate side, is the people who were threatened were the people who were making decisions on this. They really didn't have to be educated about, okay, what just happened? Well, we lived through it. We have a pretty good idea. The videos may have helped people understand stuff that wasn't within their point of view. In other words, what was going on in the other part of the Capitol where I wasn't, but it just made it even more horrific, I think, to see this attack in all its fullness. And the other thing I would add to all that is there were, as I was sitting there and seeing senators react to some of this, the reality of their having lived through it just became evident to me, that this was, yes, I mean, there's somebody crying there. There's somebody who's really shaking a head there. And there's somebody who's clearly emotional or looking down, because imagine somebody trying to attack your house, surrounding your house, breaking the windows, going in. You're going to be terrorized. And one of the remarkable things is these people who were terrorized rose up to defend their institution in the end. That's, I think, what this impeachment was ultimately about.
I was wondering if either Congressman or the Senator have any concerns about March 4th. That there are people apparently who believe that's when the passage of the presidency will take place.
Yeah, I mean, I think our law enforcement agencies will be and are preparing in a way that perhaps they weren't on January 6th. So I don't have any worries about March 4th. And when March 4th doesn't happen, QAnon will promote a new date that the transfer of power is going to happen.
He'll develop some new theory as to why that wasn't the date.
All right.
So we've got about 5 minutes left, and I've got two questions for the group. One, a sort of personal, and one larger. Let me start with the larger one, which is 50 years from now, what will history write about the second Trump impeachment? What will be the perspective that senators, congressmen, con law professors, and voters will be the takeaway from this effort to impeach President Trump? Mike, you want to start? Michael, you want to start, since you're the guy that does you're the wide lens guy, right?
Well, I'm about to write something that I'll soon regret, right? That it'll prove to be wrong. Well, I think in trying to take the long view, it's going to be inevitable that one has to grapple with the question whether or not impeachment still works. Impeachment is a process that is designed to be cumbersome, designed to be difficult. And in the case of presidents, it hasn't necessarily worked that well. The rise of political parties has become a problem in trying to get people to focus on the merits and rise above political party, much less rise above the situation to try and make a decision on the merits. And the threshold of 2/3 is awfully difficult to reach. It may be practically impossible to reach. And so I think when people look back and that threshold still in the Constitution, they may have to confront that fact, that that threshold is awfully high. But that then leads us to, I think, also have to recognize, and this is what I would write as well, is the vote is one thing, but I think there's the process is much bigger than the vote. And I think that's where the record comes into play. So one thing that's true in this situation was not true with Andrew Johnson. Everything's on tape. We have tapes of the people who were breaking into Congress. We have interviews with the senators, and we can see them give their speeches or talk to them about it in a way we couldn't with 19th century figures. And that record, therefore, for this trial will be so much more voluminous and comprehensive than any of the records in the past, that I think it's going to raise yet another question. And that is, how could people not convict this guy? You know, Donald Trump came into the White House as a con man. He left it as a con man. And it takes a gigantic leap of faith to think anything other than the fact he's a con man. And that leap of faith is awfully dangerous because it's a leap, I think, into madness. But I think the record will validate that whatever the misconduct was that Trump had committed was much greater than we even know now. All the self-dealing, for example, there's a lot of misconduct we haven't discovered yet. And 50 years from now, we're going to add that to the pile of things that both impeachments found.
I hope it just becomes sort of an asterisk in history. There's been violence in the Capitol before. The Senate cloakroom used to have a window out onto the Ohio Clock hallway. It doesn't any longer because somebody set off a bomb out in that hallway. And thankfully, nobody was hurt, but the windows were blown through by the bomb. And so they bricked them up. And the Capitol weathered this. I think the best and most important thing that happened was that we got back to work that night and went ahead with the electoral count without being disturbed. And it was a kind of a nice moment for me as a senator. David, I'm sure, had the same experience on the House side, but you could run right across the Senate, and it didn't matter your party and it didn't matter your ideology. Pretty much everybody was determined to get back that night. And to the question of, should we get back before we're sure it's safe? The answer was a resounding, oh yeah, we definitely should get back. If there is some chance that it's not safe, too damn bad, get us back there. As soon as it's not actively under the control of the mob, as soon as you have defended that room, get us back there. We have work to do and we're going to do it. And that was, I think, it just felt really good. And then when we got back and went back out onto the floor again and had reclaimed it, oh, how good that felt.
Congressman?
Yeah, I mean, I think history is going to record this as a moment that our democracy was challenged in a way that is maybe the most serious in our lifetimes, but that it withstood that challenge. As Senator Whitehouse just mentioned, this was an effort to stop the transfer of power, the meeting of the Electoral College, that important moment when the voices of tens of millions of Americans are officially recognized and our new president is elected. It was an effort to stop that. And although President Trump incited a violent mob to delay it for a few hours, he didn't stop it. We proceeded. And I think it will hopefully be remembered as a moment that American democracy survived. And I think it will also be remembered as a moment that We saw incredible examples of political courage and some of the worst political cowardice of our lifetime. And I think history is going to record the cowards and the courageous people.
So here's my
And you know
last
who you
question.
are.
So here's my last question. I'd like each of you to think about what you'd say to a young lawyer, to someone taking common law for the first time, someone taking criminal procedure, somebody thinking of going to law school. Is there a lesson from this, the importance of the legal system, about the importance of the law? And also, I'm really struck, I have to say, Senator Whitehouse, by your comment about going back on the floor and finishing the game. I mean, there's sort of almost a sports analogy here. I'd just love to hear, let me start with Professor Gerhart, since you do this every day. You speak to law students, and what's the takeaway for them? They've now been watching this since the Clinton impeachment as up close personal as probably anybody, at least not in Congress. A lesson here for our law students.
Well, I think there are a lot of lessons. I think one of them is that lawyers do make a difference, and good lawyers can make a big difference. The bad lawyers, I think, end up almost obliterating themselves. They're not taken seriously, and they kind of are therefore removed from any kind of serious participation in whatever process they're involved in. And so, and good lawyers can make a difference in how a case is presented. Also, good lawyers need to be courageous. They need to be physically courageous. Think of the lawyers in the South. I grew up in Alabama, as you know. Grew up in Alabama in the 1960s when lawyers really had to be courageous. I mean, this is one reason I became a lawyer. And so as Senator Whitehouse said, yes, if we're going to do our jobs as lawyers or do our jobs as public servants, it means we go back in. We go back in to complete what we started. That's the most important thing we can do. And so lawyers are crucial for ensuring whatever process we're talking about that's been under attack gets completed, it gets fixed, it gets protected. I also think one of the most important functions of a lawyer, I sometimes tell my students, is to speak to truth to power. That's how we put it in a fancy way. But I think of the story of the emperor having no clothes. Sometimes it's the lawyer's job to say, wait a minute, isn't what that president's doing awful? Isn't what that president's doing breaking the law? Think of both impeachments against President Trump. He was basically in each of them attacking the electoral process. That's what he was doing, which means he was attacking the American people. And in the most important way the American people speak, and that's through their voting. And so I think for lawyers to stand up and protect the votes, not just ensuring people get to vote in the ballot box, but ensure the votes get counted at the end of the process too, is critical. I mean, lawyers weren't the only ones involved here, but I think lawyers do have a special ability to be able to identify the issues that need to be argued and how they can best be argued and how the processes in which they get argued are protected and are sound so that good decision-making, democratic decision-making can be made.
Yeah, I agree.
Professor Cicilline.
I think in so many ways, the Trump administration has made me value and appreciate the work of lawyers and the courts more than maybe any time in my life. I mean, I sort of have been in politics now for 25 years and was a practicing lawyer before that. But, when you look at the relentless assault on the rule of law and our institutions and the truth by this administration for 4 years, Congress didn't hold up so well. I mean, Congress in many ways under Republican control was neutered and not really conducting meaningful oversight of this president. The political system didn't work so well. The one set of institutions that really held this administration accountable were the courts and lawyers and litigation. And whether it was the child separation policy or, you just go down the list, it was successful litigation that ultimately held the president accountable or reversed horrifically bad behavior. So I think the lesson of this administration, which culminated in the second impeachment, so, being a lawyer is a good thing because you never know when you're going to end up as an impeachment manager, but sort of all the events and all the conduct of this president, you think of the role that lawyers played in upholding the rule of law and protecting our Constitution and protecting, the institutions of our government and holding this administration accountable. I mean, it's an advertising mecca for good lawyers and how important lawyers are and what a difference our legal system makes in the lives of the American people. So I bet you, and I don't know this, but I suspect there has been a huge increase in people interested in practicing law after these 4 years because they've seen the critical work that lawyers did for the last 4 years.
Senator Whitehouse, some last words?
I would just echo what David said. We have seen a lot of corruption during the Trump administration, and particularly in administrative agencies. And over again, fake regulations that have been cooked up in corrupt manner have had to hit the courts. And in the courts, they've blown up over and over again because the courts are a crucible for winnowing out the truth. And if you look at the country's vulnerability right now to big lies, the theme of David's prosecution of this case was the big lie. Well, that was one big lie, but there was a big lie that that young volunteer for the Democratic National Committee was murdered by Hillary Clinton. And there was a big lie that Sandy Hook didn't happen, that was a put-up job but to take away gun rights. And there was a big lie, this one, about the election being stolen. And every single one of those cases, a lawyer and the survivors or the injured party have gone to court and they got big judgments against Wars and Fox News, and Dominion is all over with these multi-billion-dollar cases. Rudy Giuliani. It's nothing is more frustrating than a lie that can't be rebutted, a lie that continues despite the fact that it has been rebutted. And the courtrooms are where lies go to die and to be killed. And it really is important that when we're living in a world of big lies, that role of the courts becomes so much more important. As everybody here who's tried cases knows, little lies die in courtrooms every day and nobody notices because those lies don't threaten the well-being of our country. But oh, how much it matters. And, who knew that Professor Raskin, con law professor, First Amendment professor, would suddenly have all of his work culminate in this epic moment on the Senate floor in a proceeding that probably tipped our history. But it did. And, he was a lawyer. And I'll close by I want to, really appreciate our parliamentarians, lawyers, but they do the administrative technical work of making sure that the Senate runs and follows its precedents. Well, that night when we all went back to work, they had their offices destroyed. They'd had the presence of mind to hang on to the ballots, which would have really screwed things up. So they kept the ballots and carried them to our place of sanctuary. They came back, they had to finish up. We were gone by then. The Senate had done its business. We left at about 2:33 in the morning. They were there till 4:35 in the morning, guiding Vice President Pence through what he needed to do to complete the business before them. And then with the sun coming up, they had to go back to their destroyed offices and get ready for the next Senate day and try to put everything together again. And did it with no particular recognition as backstage players, but with perfect aplomb and perfect discipline, and just played their parts in an invisibly perfect way. And, who would have thought that lawyering would have made that big of a difference on that day, but by God, it did.
Well, our time is up. Professor Gerhart, Congressman Cicilline, Senator Whitehouse. I wish I could have written down some of the wonderful observations you made. I'm going to play the tape tomorrow. On behalf of Roger Williams School of Law, Wake Forest School of Law, and Emory School of Law, we thank you very, very much for giving us your valuable time and insights. And now I turn the program back over to Dean Greg Bowman.
Thank you, David, and thank you to everyone who participated this evening. This was fantastic. You know, it's called the rule of law for a reason. We got great historical and contemporary perspective. And to our students at the 3 law schools who are participating, listening tonight, again, all of our speakers tonight, all of our participants, they're lawyers. What we do matters, and we're glad that you are going to be in our profession and going to be our colleagues and help us with the important work of protecting our democracy in ways large and small. So again, thank you to Representative Cicilline, to Senator Whitehouse, to Professor Gerhart, and to Professor Logan for emceeing the event. And I want to thank some of our colleagues here at Roger Williams University School of Law who did not appear on the screen tonight, but who played a central role behind the scenes in making this happen. Chelsea Horn, our Director of Programs and Events. Jane Govenick, our Program and Events Coordinator. Michael Bowden, our Director of Law School Communications. Michael Donnelly Boylan, our Assistant Dean of Admissions. Raquel Ortiz, our Assistant Dean for Library and Information Services, and Associate Professor of Law. And again, Professor and former Dean David Logan, who brought his trademark high level of energy and passion to this particular event, as he does to everything he does. Thank you all again very much. Thank you to Wake Forest Law and to Emory Law again for co-sponsoring. We hope to see you again soon in a program like this soon. Thank you again. Good night.
Thank you.
Good night.